Here we go. You spot blue lights in your mirror and your stomach drops. Yet another North Carolina driver about to face a sobriety test. The officer's pen wobbles in front of your eyes, your heel to toe feels shaky, and you're wondering if one wrong move will ruin your record. Because a single slip here isn't just embarrassing, it can cost you your license, spike your insurance, and even put jail time on the table. In the next few minutes, I'll break down exactly what each roadside and chemical test means, and the smartest way to handle them. Watch through and you'll leave knowing your rights, the officer's limits, and the steps that can keep your freedom and job intact. Hi, I'm DWI attorney J. Scott Smith, and I wrote the book for lawyers in North Carolina about how to try DWI cases. If you've been pulled over for suspected DWI in North Carolina, you're facing what could be one of the most challenging legal situations of your life. And if you're watching this video, chances are you're wondering about sobriety tests, what they mean, and what your rights are. Well, I'm going to walk you through everything you need to know about DWI sobriety tests in North Carolina, from the moment you see those blue lights in your rearview mirror to understanding what happens if you refuse those tests. First, let's discuss what are DWI sobriety tests in North Carolina. When we talk about DWI sobriety tests in North Carolina, we're talking about two different categories of tests. You have your field sobriety tests, which are those physical coordination tests that officers perform roadside, and you have your chemical tests, which measure the actual alcohol content in your system through breath, blood, or urine. The field sobriety tests are what most people think of when they hear sobriety test. These are the tests where the officer asks you to walk in a straight line, stand on one foot, or follow a pin with your eyes. These tests are designed to give the officer probable cause to arrest you for DWI. The chemical tests, on the other hand, are what the state will try to use to prove you are actually impaired. In North Carolina, we have what's called implied consent, which means that by driving on our roads, you've already agreed to submit to a chemical testing if you're arrested for DWI. But here's what's critical to understand. These two types of tests have completely different legal implications, and your rights regarding each one are different too. The three standardized field sobriety tests. Let's start with the field sobriety test. The National Highway Traffic Safety Administration has approved three standardized field sobriety tests, and these are the ones that North Carolina law enforcement typically use. Understanding these tests are crucial because they're often the foundation of the state's case against you. The first test is the horizontal gaze nystagmus test, or HGN. This is where the officer holds a pen or a small flashlight about 12 to 15 inches from your face and asks you to follow it with your eyes as they move it from side to side. What they're looking for is an involuntary jerking of your eyes, which can be more pronounced when someone's been drinking. Now, here's what you need to know about this test. It's not foolproof. There are dozens of medical conditions, medications, and even natural causes that can cause nystagmus. If you have an inner ear problem, if you're taking certain prescription medications, if you have a head injury, or even if you're just naturally prone to eye jerking, this test can give a false positive. The second test is the walk and turn test. The officer will ask you to take 9 steps in a straight line, heel to toe, turn around in a specific way, and then take 9 steps back. They're looking for 8 different clues of impairment, including starting before they tell you to, not touching heel to toe, stepping off the line, using your arms for balance, making an improper turn, or taking the wrong number of steps. The problem with this test is it's what we call a divided attention test. You're supposed to listen to the instructions, remember them, and then perform a physical task. But many people who are completely sober can fail this test simply because they're nervous, they're not athletic, they have physical limitations, or they're wearing inappropriate shoes. The third test is the one-leg stand test. You'll be asked to stand on one foot with the other foot about 6 inches off the ground and count out loud for 30 seconds. The officer is looking for swaying, using your arms for balance, hopping, or putting your foot down. Again, this test can be affected by age, weight, physical fitness, medical conditions, or even the surface you're standing on. If you're on the side of a busy highway with cars whizzing by, or if the ground is uneven, or if you have any kind of leg or back problem, this test becomes unreliable. Your rights regarding field sobriety tests. Here's something that might surprise you. In North Carolina, you have the right to refuse field sobriety tests. That's right. You're not legally required to perform these tests at all. There's no automatic penalty for refusing them like there is with chemical tests. But, and this is important, refusing field sobriety tests doesn't mean you won't be arrested. If the officer has other evidence of impairment like an odor of alcohol, slurred speech, bloodshot eyes, or your driving pattern, they can still arrest you for DWI. The question becomes, is it better to refuse these tests or to take them? This is where the legal strategy comes in, and it depends on your specific situation. If you take the test and perform poorly, the state now has evidence they can use against you in court. The officer will testify about how you failed these tests, and the testimony can be powerful to a jury. But if you refuse the test, the state can't use that evidence against you. However, the prosecutor can still mention that you refused, and they might argue that you refused because you were impaired. In my experience, if you've been drinking and you know you're impaired, refusing these tests often puts you in a better position. But if you're completely sober and confident in your ability to perform these tests, taking them might help your case. Chemical tests and North Carolina's implied consent law. Now let's talk about chemical tests, because this is where things get more serious. North Carolina General Statute 20-16.2 establishes our implied consent law. This law says that anyone who drives in North Carolina roads has given their consent to chemical testing if they're arrested for DWI. The chemical test is typically a breath test using a device called the Intox ECIR2, though it can also be a blood test or a urine test. The officer must read you your rights under the implied consent law before asking you to submit to the test. Here's what the officer must tell you. You have the right to refuse the test, but if you refuse, your license will be revoked for at least 1 year. They must also tell you that you have the right to call a witness to observe the test, and you have the right to have your own chemical test performed. If you refuse the chemical test, there are immediate consequences. Your license will be revoked for 1 year for a first refusal, 2 years for a second refusal, and permanently for a third refusal. This happens through the DMV regardless of what happens in your criminal case. But here's the thing, the state can still prosecute you for DWI even if you refuse a chemical test. They'll use other evidence like your driving, your behavior, the officer's observations, and any field sobriety tests that you may have taken. The Intox ECIR2 and breath test reliability. Let's talk specifically about the breath test because it's the most common chemical test used in North Carolina. The state uses a machine called the Intox ECIR2, and while this machine is generally reliable, it's not infallible. The ECIR2 measures the amount of alcohol in your breath and converts that to an estimate of your blood alcohol concentration. But several factors can affect the accuracy of this test. First, the machine must be properly calibrated and maintained. North Carolina has specific requirements for how often these machines must be checked and calibrated, and if those requirements aren't met, the test results can be challenged. Second, the person administering the test must be properly trained and certified. The officer must observe you for at least 15 minutes before the test to make sure you don't burp, vomit, or put anything in your mouth that could affect the results. Third, certain medical conditions can affect the results. If you have acid reflux, diabetes, or certain other medical conditions, the breath test might show a higher reading than your actual blood alcohol level. Fourth, the test must be administered properly. There are specific protocols that must be followed, and if the officer doesn't follow these protocols, the results can be suppressed. Blood tests and when they're used. Sometimes instead of a breath test, the state will want a blood test. This typically happens in serious cases like where there's been an accident with injuries or when the officer suspects drug impairment in addition to or instead of alcohol. Blood tests are generally more accurate than breath tests, but they're also more invasive. The state must have a search warrant to take your blood unless you consent or there are exigent circumstances. In the 2013 case of Missouri versus McNeely, the U.S. Supreme Court ruled that the natural dissipation of alcohol in the bloodstream doesn't create a per se exigency that justifies a warrantless blood draw. This means that in most cases, law enforcement needs a warrant to take your blood. However, North Carolina has a statutory provision that allows for a warrantless blood draw in certain circumstances, such as when there's been a crash resulting in a serious injury or death. But even in those cases, the Fourth Amendment protections will still apply, and these blood draws can be challenged. Understanding BAC levels and legal limits. In North Carolina, you're considered legally impaired if your blood alcohol concentration is 0.08 or higher. But here's something important. You can still be convicted of DWI even if your BAC is below a 0.08. North Carolina law recognizes two theories of DWI. The first is the per se theory, which says that if your BAC is 0.08 or higher, you're impaired as a matter of law. The second is appreciable impairment theory, which says that if you're appreciably impaired by alcohol or drugs, you can be convicted regardless of the BAC. This means that even if you blow a 0.06 or a 0.07, the state can still prosecute you for DWI if they can prove that you were appreciably impaired. They'll use evidence like your driving pattern, your performance on field sobriety tests, and the officer's observation of your behavior. On the other hand, if you blow over a 0.08, the state doesn't have to prove that you were actually impaired. The high BAC is proof enough under the per se theory, the 15-minute observation period. One of the critical requirements for a valid breath test is the 15-minute observation period. Before administering the breath test, the officer must observe you continuously for at least 15 minutes to ensure that you don't do anything that could affect the results. During this observation period, you cannot burp, vomit, smoke, chew gum, or put anything in your mouth. If you do any of these things, the officer is supposed to start the 15-minute period over again. The reason for this observation period is that alcohol in your mouth can give a falsely high reading on the breath test. If you burp, for example, alcohol from your stomach can come up into your mouth and affect the results. The observation period is fertile ground for challenging breath test results. If the officer didn't properly observe you for the full 15 minutes, or if they allowed you to do something that should have restarted the observation period, the test results can be suppressed. Medical conditions that can affect test results. There are several medical conditions that can affect the accuracy of both breath and blood tests. Understanding these conditions is important because they can provide a defense to DWI charges. Acid reflux or GERD can cause alcohol from your stomach to come up into your mouth, leading to a falsely high breath test result. This is sometimes called mouth alcohol, and it can significantly affect the accuracy of the intoxilizer. Diabetes can also affect breath test results. When diabetics don't have their blood sugar under control, their bodies can produce acetone, which will register as alcohol on some breath testing devices. Certain medicines can affect test results as well. Some cough medicines, mouthwashes, and even some foods can contain alcohol that could affect a breath test. Dental work can also be a factor. If you have dental bridges, crowns, or other dental work, alcohol can become trapped in these areas and affect the breath test results. Challenging sobriety test results. If you've been charged with DWI based on sobriety test results, there are several ways these results can be challenged in court. For field sobriety tests, we can challenge whether the tests were administered properly. The officer must follow specific protocols for each test, and if they deviate from these protocols, the results can be suppressed. We can also challenge the conditions under which the tests were performed. If the ground was uneven, if the lighting was poor, if you were wearing inappropriate shoes, or if there were other factors that could have affected your performance, these can all be used to challenge the results. For chemical tests, we can challenge the maintenance and the calibration of the testing equipment. North Carolina has specific requirements for how often these machines must be checked and calibrated. And if these requirements aren't met, the results can be challenged. We can challenge the qualifications of the person who administered the test. The officer must be properly trained and certified to administer chemical tests, and if they're not, the results can be suppressed. We can challenge whether the proper procedures are followed. If the officer didn't observe you for the required 15 minutes, or if they didn't follow the proper protocols for the test, the results can be challenged. The role of video evidence. Many DWI stops are recorded on the officer's dash camera or body camera, and the video evidence can be crucial in challenging sobriety test results. The video can show whether the officer properly administered the field sobriety test, whether you actually performed as poorly as the officer claims, and whether there were factors that could have affected your performance. Sometimes the video shows that you performed better on the field sobriety test than the officer's report says. Other times, the video shows that the officers didn't follow proper procedures. The video can also show your demeanor and behavior during the stop. If you appear coherent and cooperative on the video, this can contradict the officer's testimony about your level of impairment. Administrative license revocation. One thing that catches many people off guard is that your license can be revoked through the DMV even before you've been convicted of DWI. This is called an administrative license revocation, or ALR. If you refuse a chemical test, your license is automatically revoked for 1 year. If you take the test and blow a .08 or higher, your license is revoked for 30 days. You have the right to request a hearing to challenge this revocation, but you must request this hearing within 10 days of your arrest. If you don't request a hearing within the 10 days, you lose your right to challenge the revocation. At the administrative hearing, you can challenge whether the officer has reasonable grounds to believe you were impaired, whether you were properly informed of your rights, and whether you actually refused the test or blew over the legal limit. Winning a hearing can be challenging, but it's not impossible. Even if you don't win the hearing, it gives us an opportunity to question the officer under oath and lock in their testimony, which can be valuable for your criminal case. The importance of witness testimony. North Carolina's implied consent law gives you the right to call a witness to observe your chemical test. This is a right that many people don't know about. It can be crucial to your defense. If you have a friend or a family member who can come to the jail or testing facility, they can observe the test and potentially testify about what they saw. They can testify about your demeanor, about whether the officer followed proper proper procedures and about any factors that might have affected the test results. You also have the right to have your own chemical test performed. If you take the state's test and then have your own test done shortly afterward and the results are different, this can be used to challenge the accuracy of the state's test. Understanding the consequences of refusal. The decision of whether to refuse a chemical test is one of the most important decisions you'll make during a DWI stop. There are serious consequences either way. If you refuse the test, your license will be revoked for at least 1 year. This revocation is automatic and happens through the DMV, regardless of what happens in your criminal case. But if you take the test and blow over the legal limit, the state now has powerful evidence against you. A high BAC reading can be very difficult to overcome in court. In some cases, refusing the test might be the better strategic decision. If you know you're impaired and you know you're going to blow over the legal limit, refusing the test might give you a better chance of avoiding a conviction. But in other cases, taking the test might be better if you're not impaired and you're confident that you'll blow under. Taking the test might help your case. This is a decision that depends on your specific situation, and it's one that you have to make quickly, often under stressful circumstances. Field sobriety test and physical limitations. One of the problems with field sobriety tests is that they don't account for physical limitations. If you had a bad back, if you have a problem with your balance, if you're overweight, if you have any other physical limitations, these tests can be unfair. The walk and turn test, for example, requires you to walk heel to toe in a straight line. If you have problems with your balance or you're not physically fit, you might fail this test even though you're completely sober. The one-leg stand test requires you to stand on one foot for 30 seconds. If you have problems with your balance, if you're overweight, or if you have any kind of back or leg problem, this test can be very difficult. Even the HGN test can be affected by medical conditions. If you have an inner ear problem, if you're taking certain medications, or if you've had a head injury, this test can give you a false positive. If you have any physical limitations that could affect your performance on these tests, it's important to let your attorney know. These limitations can be used to challenge the reliability of the test results. The science behind BAC calculations. Understanding how blood alcohol concentration is calculated can be important for your defense. BAC is typically expressed as a percentage such as 0.08%, which means 0.08% of your blood is alcohol. But BAC is not constant. It rises and falls as your body absorbs and metabolizes alcohol. This means that your BAC at the time of the test might be different from your BAC at the time you were driving. If you were tested an hour or two after you were driving, your BAC might have been lower when you were actually driving. This is called retrograde extrapolation, and it can be used to challenge the relevance of the test results. On the other hand, if you were still absorbing alcohol when you were driving, your BAC might have been lower when you were driving than when you were tested. This is called the rising BAC defense. The timing of the test in relation to when you were driving can be crucial to your defense. Prescription medications and DWI. It's important to understand that you can be charged with DWI even if you're impaired by prescription drugs. North Carolina law prohibits driving under the influence of any impairing substance, including prescription drugs. This can be particularly problematic because many prescription medications can cause impairment, even when taken as prescribed. Pain medications, anxiety medications, sleep aids, and even some antidepressants can affect your ability to drive safe. If you're taking prescription medications and you're stopped for DWI, it's important to let the officer know about your medications. But be careful about what you say because your statements can be used against you. The officer might ask you to submit to a blood test to check for drugs in your system. The same implied consent law that applies to alcohol also applies to drugs. The importance of legal representation. If you've been charged with DWI based on sobriety test results, it's crucial that you have experienced legal counsel. DWI law is complex and there are many technical defenses that can be raised. An experienced DWI attorney will know how to challenge the administration of field sobriety tests, how to attack the reliability of chemical test results, and how to identify violations of your constitutional rights. They'll also know how to negotiate with prosecutors and how to present your case to a jury if it goes to trial. DWI cases often involve complex scientific evidence, and it takes experience to know how to effectively challenge this evidence. What happens if you're convicted? If you're convicted of DWI in North Carolina, the consequences can be severe. For a first offense, you're looking at a fine of up to $200, up to 24 hours in jail, and a 1-year license revocation. But the real consequences often go beyond the legal penalties. A DWI conviction can affect your job, your insurance rates, and your ability to get certain types of employment. If you're a commercial driver, a DWI conviction can end your career. If you're a professional who holds a license, such as a doctor, lawyer, or a teacher, a DWI conviction can affect your professional license. This is why it's so important to fight DWI charges aggressively. Even if the evidence seems strong, there are often defenses available. Building your defense strategy. Every DWI case is different, and the defense strategy depends on the specific facts of your case. But there are some common themes that run through most successful DWI defenses. First, we look at whether the officer has reasonable suspicion to stop you. If the stop was illegal, any evidence obtained as a result of the stop can be suppressed. Second, we look at whether the officer had probable cause to arrest you. If the arrest was illegal, the chemical test results can be suppressed. Third, we look at whether the field sobriety tests were administered properly and whether your performance was actually indicative of impairment. Fourth, we look into whether the chemical test was administered properly and whether the results are reliable. Fifth, we look at whether your constitutional rights were violated at any point during the process. The role of expert witnesses. In many DWI cases, expert witnesses can be crucial to the defense. These might include toxicologists who can testify about the reliability of the chemical test results, medical experts who can testify about medical conditions that might affect test results, or forensic experts who can testify about the proper administration of field sobriety tests. Expert witnesses can help explain complex scientific concepts to a jury and can help identify problems with the state's evidence. For example, a toxicologist might testify that the breath test results are unreliable because the machine wasn't properly calibrated or because the test was administered improperly. A medical expert might testify that your performance on the field sobriety test was affected by a medical condition rather than by alcohol. Conclusion and next steps. Understanding DWI sobriety tests in North Carolina is crucial if you've been charged with this offense. These tests are not foolproof, and there are many ways they can be challenged. Field sobriety tests are subjective and can be affected by numerous factors, and they have nothing to do with alcohol impairment. Chemical tests, while more objective, can be unreliable if they're not administered properly or if there are factors that affect their accuracy. If you've been charged with DWI, don't assume that the test results are conclusive evidence of your guilt. There are many defenses available, but they require experienced legal representation to identify and pursue. The key is to act quickly. Evidence can disappear, witnesses' memories can fade, and there are deadlines that must be met. The sooner you get an experienced DWI attorney involved in your case, the better your chances are of achieving a favorable outcome. Now, while we've covered the fundamentals of sobriety tests and how they can impact your case, there's another critical aspect that many people don't consider until it's too late. If you hold a commercial driver's license or a CDL, the stakes are even higher. A DWI conviction doesn't just affect your regular driving privileges, it can destroy your livelihood entirely. In my next video, I'm going to break down everything you need to know about DWI and your CDL, including the harsh reality of commercial driver consequences that most people never see coming. You'll learn about the federal regulations that can end your driving career and the lower BAC limits that apply to commercial drivers, and the specific steps you need to take right now to protect both your license and your job. This isn't just about understanding the law, it's about protecting your ability to provide for your family. If you drive commercially or if you're considering getting your CDL, this information could save your career. See you over there. And remember, arrested doesn't mean guilty.